Ms. Anderson had filed a request for temporary orders, Mr. McMullen, that were submitted and were not executed before there was an entry of appearance due to a clerk error in signing documents and then having to reject them and then having to have them resubmitted. That's never happened before. I'm hopeful that it won't happen again. It didn't just happen to this case, it happened to a number of cases. And so I apologize to your client. As I indicated, though, temporary orders don't have to be signed as submitted. However, I believe that your requests were quite reasonable. So basically, Mr. Potter, you have filed some exhibits. I assume, Mr. McMullen, you still want to adopt the temporary orders you submitted, correct?
Yes, Your Honor.
All right, so Mr. Potter, you can argue why you don't think those temporary orders should be issued or approved by the court.
Thank you, Your Honor, and we are here today to ask the court to issue temporary orders in this case, but really what we're here for is some guidance and some help from the court to help educate these parties and give them an expectation as to whether or not what they want in this case is realistic. And what is encouraging is we agree on a number of factors. We agree that we have two good parents. We agree that they both love these boys and that they're both capable and that they should be given joint legal custody, as that term is defined by Kansas law. And what that helps us establish then, Your Honor, is that the law presumes if we have two good parents, then they're entitled to reasonable parenting time. And that's set by statute under KSA 233208. And what it says is that presumed parents that have the best interests of their child at heart are entitled to that parenting time unless the court can make a finding that parenting time would be harmful to these boys. And that certainly isn't the case in this matter. We are fortunate, like I said, that we have two good parents. And even though we can acknowledge that Greg does work full time, he's been able to work from home on occasion. And since this case was filed, he's been able to secure a guarantee from his employer that he can continue to work from home. He can and does feed these boys, he bathes them, he puts them to bed, he cares for them when they're sick, he gets them where they're going to and from. And since the law presumes that we have equally capable parents, then we believe that they should have equal parenting time. And once we've established that point, then we look at the factors of what is in the children's best interests. And when we're trying to determine whether or not a parent is supportive of the relationship between children and the other parent, looking at the proposal that's being put forth by the petitioner, I think you can see that the parenting time that's provided isn't reasonable. A few hours a week, when just 10 days ago we were all residing together under the same roof, isn't reasonable. Greg has not seen these boys since July 14 for any meaningful time since the petitioner took them and left the residence. Petitioner told the boys about the divorce, and while I appreciate that we need to be respectful of everyone's perspective of the history of this case, it's just that. It's perspective. And one perspective isn't more valid than another. And it's important to remember that perspectives aren't facts. If the petitioner believes, as she has alleged, that these parties should have joint legal custody, then that means they should be treated equally as parents. There is nothing in the information that has been provided to you in the case file that indicates that Greg isn't a capable parent entitled to reasonable parenting time under the statute. So for a temporary order, we're asking the court to grant joint legal custody, shared residency, and shared parenting time that's set forth in our proposed parenting plan. The other issues that we have essentially for today, for the bigger picture, is possession of the residence and then monetary payments for child support or spousal maintenance. As I stated, the petitioner left the residence voluntarily. Greg has been in the residence, he's maintained the residence, he should be allowed to do so. And once the court grants him reasonable parenting time, that will mean that the boys will be with him in the home that they know, so that there won't be any issues as far as adjustment are concerned, so that they can be comfortable during that parenting time and hopefully allay some of these concerns that petitioner seems to be voicing regarding Greg and his parenting abilities. But as we talk about that, and if we do say that Greg remains in the home, then we would simply say that he should pay the mortgage that's against the home. And as the court then is evaluating the issues of spousal maintenance and child support, we would need to look at the parties' domestic relations affidavits. And you have both of those on file. And when we look at the petitioners, we see a few gaps. One, petitioner is voluntarily underemployed. Two, she failed to include in her domestic relations affidavit an amount of child support that she's proposing that's included in her temporary orders. Three, if Greg does go ahead and pay the mortgage, then that gives her a more disposable income. But the reality of this situation, Your Honor, is this is a short-term marriage. And when we look at the factors that are involved in awarding spousal maintenance in Kansas, we have a statute, and it is based upon one party's ability to pay and one party's need. Simply applying percentages to what we believe are the party's incomes is not the law, and that isn't what should happen in this case. Added to that, when we look at Greg's domestic relations affidavit, you can see that he does not have an ability to pay. He's already negative. And if we would add spousal maintenance on top of that, we're simply going to make a bad situation worse. What it comes down to is this, Your Honor. History is important, and we certainly need to take that into consideration. But no matter what these parties did or didn't do while they were together, when the petition for divorce is filed, then things are going to have to change on both sides. If we are going to make sure that Greg is able to have a good and meaningful relationship with these children, 2 or 3 hours a week isn't gonna do it. I haven't seen that proposed before in a situation where there isn't abuse or abandonment or something like that. And
so what are you proposing?
Shared residency and shared parenting time, Your Honor. We filed a proposed parenting plan that essentially would split the week between the parties on a Monday, Tuesday, Wednesday, Thursday basis, and then alternate weekends. I understand from the petitioner that she's opposing who has Monday or Tuesday or Wednesday or Thursday. We don't care. Whichever side she wants, we'll take the other side, and we can go from that point.
Okay. How much equity is in this particular house? Because the DRA I saw didn't tell me what the value of the house was. And it didn't tell me the mortgage. It told me the payment of $1,800 a month or something.
Maybe 160, Your Honor. We don't have a value of the house, and so I'm not exactly sure how much.
Well, just tell me what the tax value is on it, what the taxable appraisal is.
I don't know that either, Your Honor. I was just retained this week, so I haven't had a chance.
Your client doesn't know what his house is appraised for by the taxing authorities of Butler County?
I'm sorry, Your Honor. I don't have that in front of me. If I would have known, I can certainly provide that to the court before the end of today.
That's fine. So what relatives or alternative housing does your client have?
His mother lives in Derby. Petitioner is staying with her parents just, I think, a couple of minutes away from the marital residence.
Okay. All right, Mr. McMullen.
Thank you, Your Honor. Your Honor, I'm gonna provide a little bit more background into these parties' marriage. Your Honor, these parties have been married since 2019. They have 2 kids, one of who just turned 6 a couple weeks ago, and one of who is 2. Mom currently works part-time. She works on Tuesday, Wednesday, and Thursday. Again, I would say she's not voluntarily unemployed. That's been a process that the parties have been using for an extended period of time so that the parties don't have to pay daycare. She watches the kids on Monday. She watches the kids on Friday. My client's mother, the maternal grandma, watches the kids on Tuesday, Wednesday, Thursday when she is at work. In 2020, when shortly after the party's oldest child was born, this is a theme that's developed throughout the entirety of the marriage. The dad indicated that he has been overwhelmed by everything, and overwhelmed by the marriage, overwhelmed by fatherhood. He left the marital residence for multiple months from the time the oldest was 6 months old until it was nearly 11 months old, only returning after mom asked him to. During that time, his visits were incredibly minimal, and most of the time were initiated by mom. That seems to have been a pattern that's continued. Your Honor, when this party's youngest child was born in 2023, Dad again began to indicate feelings of being overwhelmed. He has moved himself into the basement of the marital residence, essentially living separately and having limited levels of interaction with both mom and the parents since 2020, or both mom and the party's kids, Your Honor, since 2023. Dad will frequently hold himself up in the basement, and not interact with the family, including for up to periods of several days have happened during the last couple of years that he's been in the basement. He'll sleep until 11 o'clock in the morning on Saturdays, and the parties will just kind of operate and go about their day without it. And that's been a relatively normal behavior that's happened since 2023 as the party's kids have been older. During this entirety of the marriage, since the kids have been born, mom has been the primary caregiver of the children, and dad's rarely ever been solely responsible for even one of the children for an extended period of times. He's never been responsible for the children overnight, especially for the extended period of time that he's asked for. He's asked to be solely responsible for kids for multiple days when that's not ever been the case. Even when mom is around, he's never had the kids overnight by himself. Frequently, if mom has to run errands or do something without the kids, she'll ask her own mom, the maternal grandmother, to come over to the house and watch the kids, despite dad's being available. Frequently, maternal grandmother comes over and watches the kids and doesn't even know that dad's home because dad is hanging out in the basement and not spending time with the kids. On rare occasions when mom does have to leave the kids with dad for short periods of times, she'll try to put the kids down for a nap before she leaves. Dad will text mom, hey, the kids are awake, you need to come home. Hey, the kids are awake, and rush her home. And mom has to cut what she's doing short and try to come home, or explain to dad, oh, give him snacks and he'll be okay. Dad doesn't know if he can get him to go back to sleep, despite the fact that they're 2 years old, and doesn't know that he needs to pay attention and spend time with the kids once they're awake from their naps. Frequently becomes frustrated with the kids, Your Honors. Recently, as a couple weeks ago, dad will take out anger and frustration with the kids. He's pushed the oldest child down at a company event in front of parents, in front of other people that he works with, pushed the 6-year-old to the ground because he's frustrated with his behavior in front of everybody. Your Honor, we don't contend that he's not a parent who's can't be partly responsible or can't contribute to decision-making abilities with the parents, and shouldn't have the ability to have medical information or anything like that related to the kids that comes with joint legal custody. But we don't think that just because he has the ability to help make co-parenting decisions or have access to medical information is the same as saying that he should have an equal amount of parenting time. We believe that the parenting time that we've laid out is reasonable given the circumstances. He's never had overnights with the kids by himself. He's hardly ever had extended periods of time with the kids by themselves. He's not been the parent who takes them to the doctor. He's not been the parent who sets up medical appointments. He's hardly ever the parent who feeds them. As recently as a couple weeks ago, dad doesn't know what size clothes the oldest wears, was surprised to learn that the oldest isn't wearing toddler size clothes anymore. doesn't know which shoes belong to which kids, tries to put the 2-year-old shoes on the 6-year-old, tries to put the 6-year-old shoes on the 2-year-old, becomes frustrated with the kids when he's putting the shoes on the wrong kid. Just wholly uninvolved in a lot of those aspects, doesn't know how to pack the bag for the kids. His indication that he hasn't seen the kids since the divorce was filed, that's not correct. My clients offered FaceTime calls multiple times, said call whenever you want, FaceTime the kids whenever you want. He's declined to do so. He's had a couple of FaceTime calls because my client's the person who initiates those, so that the kids have a chance to see their dad. Dad is, again, as recently as this last week, since the filing, mom offered parenting time to dad, offered to let dad take him to the pool, and he indicated that he didn't think it would be safe for him to have both kids at the pool without Emily present. So he decided that he wasn't going to take the kids to the pool on his own, and instead went to the park with the kids. He brought his mom to help him with the kids while he was at the park, was there for less than 2.5 hours, and then returned the kids to mom's care. So he's had opportunities to spend time with the kids since the divorce has been filed. He hasn't really taken those, and the one time that he did, he decided that he couldn't handle him at the pool and brought someone with him to the park. Your Honor, also to let you know that my client still breastfeeds the youngest child. He's 2. He breastfeeds before he goes to bed, if he wakes up in the middle of the night, sometimes before his naps. Multiple times a week, he's breastfeeding with my client. And so, Your Honor, for all of those reasons, we believe that frequent short periods of time with the party's kids is what's best for the kids. It's what's best for dad to make sure that he doesn't get overwhelmed and frustrated with the kids. We're open to domestic conciliation or parent coordination in this case to try to figure out how frequent those visits could be. Your Honor, I believe we were talking about Monday evenings from 5 to 8, Wednesday evenings or Thursday evenings, and then every Sunday, so he gets to see the kids every couple days for limited periods of time. Just the request that he all of a sudden have overnight visitation and be solely responsible for them for 72 hours in a row is completely and wholly separate than anything these parties have ever done throughout their marriage. Indication that they were, all living and together in the residence and spending equal amount of time together as recently as a week ago is not correct. Like I said, he's been living in the basement separate from the children and from mom for a long period of time. As for the temporary orders, Your Honor, we believe all the provisions that we put in there are more than fair. Mom is home 2 days a week with the kids. The kids are comfortable and used to the marital residence. It's their bedrooms. It's their place where they live. It's their place where they spend every Monday and Friday with mom unequivocally and have for a long period of time. Mom's offered to pay half the mortgage despite the fact that she only works part-time to help with the kids, that she should retain possession of that marital residence, that she's the primary caregiver and that's where the kids are comfortable. So that's where she and the kids should be. Dad's got family in the area and over in Derby are also just minutes away. It's the difference between 5 minutes and 20 minutes, I believe. So he's got family that he can stay with. And as indicated on dad's DRA and child support worksheet, his income is even higher than we initially indicated it was. We think that, obviously child support would need to be recalculated with dad's new income that he's indicated, but our nominal amount of spousal maintenance that we've requested, we believe is extremely reasonable, considering the fact that my client is working part-time to help provide for the kids and care for the kids during the week, and dad's income is even higher than we originally indicated. So we believe that child support should be calculated per the guidelines, and we're asking that you adopt our proposed temporary parenting plan. Like I said, we're open to giving dad an additional evening weekday parenting time so that he has more frequent visits with the party's children. But we do believe, Your Honor, that the more frequent, shorter periods of time for the parenting time with dad is more consistent with what the parties have been doing since the kids were born and is what's in the best interest of the kids going forward.
Is your client pumping that she can provide bottles? Does she have frozen milk?
No, Your Honor.
And if I could briefly respond, Your Honor.
Yes.
First and foremost, statements of counsel aren't evidence.
I
If-
understand.
If we had all of these text messages and all of this information, then it should have been provided to the court in support of this limited parenting time. If you would like, I'd be happy to send you the text messages between the parties in the last 10 days where Greg has repeatedly asked for parenting time and been denied. The simple fact of the matter, Your Honor, is this. Petitioner asked for joint legal custody. The law presumes that these are fit parents. There isn't anything here that indicates that Greg isn't capable of taking care of these children on an overnight basis. At the very least, he should have overnights for weekends and sometime during the week. A couple of hours, 2 times a week, isn't going to allow him to maintain a meaningful relationship with these children. There's no basis for it based upon the information that the court has in front of it today.
Your Honor,
Well, I'm a little concerned about how to handle the breastfeeding situation. I think I'm going to need a letter from the pediatrician about the breastfeeding and whether or not mom can pump. But what I'm inclined to do today, just so we can get an actual evidentiary hearing, is to keep dad in the home paying all of the mortgage so that they're close together, since mom has family in town close where she's at. This is again temporary. To grant mom $500 in spousal support monthly, and to give dad every other weekend, starting this Saturday from 9 a.m. to 6 p.m. on Sunday, and then his off weekends, Tuesday at 6 p.m. to Thursday at 6 p.m. And then all other, you haven't addressed any other assets or liabilities, payments. But I think everything else in the temporary order can be adopted unless there's something in particular you want to address, Mr. Potter.
I think, Your Honor, the only thing with Mr. McMullen's statements, petitioner paying half of the mortgage, we're fine with that since the court has ordered spousal maintenance.
No, if he gets the home, he can pay the full mortgage.
Okay.
If she got the home, I would have her paying half, but he can pay the full mortgage. He makes twice as much as she does. And you can talk about underemployment later when it comes to finalization of the matter. I do want to send them to domestic conciliation while you're working out the asset situation. It's always difficult with a marital home. Who can realistically afford it? What's fair? Sometimes it means it has to be sold, so each side can get a little bit of money to start over for a down payment and get free of the mortgage so that they can get their own loan. You want to do a reality check, Mr. Potter. The reality is when people get divorced, they split everything in half. So what they've accumulated, whether it's 9 years or 19 or 29 years, is split in half. They have half of what they had, and that's a reality. And they have to take on roles that they maybe did not have previously, with regard to parenting and sharing of parenting time and co-parenting. And so there are a lot of adjustments and there are a lot of changes, and the law does require that the court make an effort to give a sufficient amount of time with both parents. And so I feel like I need to do that, in this case. But, we'll see what happens with domestic conciliation. I also am going to ask your client, Mr. Potter, to get a psych assessment. He can do that wherever he wants. Prairie View, South Central Mental Health. They have one in Andover, Augusta, El Dorado. I don't care where he goes, but I want him to get an assessment. I want to be assured that he's not suffering from depression. I want to be assured that he's not too overwhelmed for these kids, and I want to be sure that he's processing this divorce effectively to be able to parent on his parenting time.
Understood,
So
Your Honor.
I do want that appointment made the next week, and I want him to have that assessment. I think probably the Andover Collaborative Resources is probably the best place for him to go for domestic conciliation. What else? Mr. McMullen.
Your Honor, I want to just make sure I heard right about the off week weekday parenting time for dad. You said Tuesday from 6 p.m. to Thursday at 6 p.m.
Yes.
Your Honor, what would you like the parties to do with the kids during the day on Wednesday and Thursday? Historically, they've been at maternal grandparents. I know Dad's saying that he gets to work from home, but how is he? I mean, there's a 6-year-old and a 2-year-old that
Right.
he would be responsible for during the day while he's at work. Even if he's at home, that's a lot of things to juggle. We would say that we would want the kids to be with maternal grandparents while he's at work. That's what the kids are used to, Your Honor. And that's where mom will be residing, so it won't be too much of a switch for them as well.
What are your, Mr. Potter, what are your clients' hours?
Usually from 8 to 5, Your Honor, but again, he's made arrangements that he can work from home. He's
But
also
I agree. Have you ever had, you have a 2-year-old? Ever had a 2-year-old?
I have, Your Honor. I understand that they're a battery with legs. I appreciate that. My what I would say is that Greg's mother lives in Derby. She's able to take care of both of the boys, and if we needed to utilize Petitioner's mother as daycare, I think I would just say if we have those two persons available, Greg can make arrangements during his parenting time.
Your Honor, regarding that, I would say that the maternal grandparents have historically been the care providers for these kids. That's who they're comfortable with. My client to me that paternal grandmother has been wholly has not been that involved.
Okay. Okay. Well, what I'm going to do is require that they go to maternal grandparents' house during the day. I don't think he can work and watch a 2-year-old, and a 6-year-old can't look after a 2-year-old, and those two together, I don't think that's a safe situation, frankly. But the Sunday before his weekday time, if he wants to give notice that he doesn't need the grandparents and his mother wants to come over and watch the kids, that's fine.
Okay.
Or if he wants to take him there. Now, there is a right of first refusal for overnights. So you don't get to take the kids to Grandma in Derby at 6 o'clock on Tuesday and not get them till 6 o'clock on Wednesday, and then take them back at 8. They can't. I don't want them spending the night, and I don't want them having to travel a lot. I'm not saying they can't go to Derby and have fun there with their grandmother if she wants to. But as far as actual daycare, the primary daycare provider will be the maternal grandparents. And if the paternal grandmother or grandparents want to exercise time during his time, he just needs to give notice on the Sunday before at 6 p.m. that he's got other arrangements for them, so that the maternal grandparents can make plans to do their own things. Then I think we probably need to get on a parenting app.
I think we've agreed on OFW, Your Honor.
Okay, great.
I
What
don't want to speak for Mr. McMullen, but I think we've agreed on that.
Any objection, our family wizard?
Your Honor, I believe that's a good idea as well.
Okay. Do you think, Mr. McMullen, that you could take these temporary orders and make some revisions and resubmit them to the court?
Yes, Your Honor, I
Or
can do that.
want me, to have Mr. Potter draft
I can do that, Your Honor.
the orders? Okay.
And I think we're working off of pretty similar forms, Your Honor, so I'm certain that Mr. McMullen can prepare that. I do have one question as far as transportation. My suggestion would be the parent that's going to exercise parenting time picks the children up from the other parent's home at the beginning.
Yeah, you can do it either way, or if it's their time, you drop them off or you pick them up. It does,
Okay.
same thing, but,
Right. And for domestic conciliation, it's collaborative success with Melissa Meyer. Is that
yes,
what you ordered,
please.
Your Honor?
Yes,
Okay.
please.
Thank you.
Yeah, I would say transportation is just you pick them up for your time to exercise your time. And if your client, Mr. Potter, finds that this is very difficult, then, like I said, I did the right of refusal. Let's make sure that the parenting time is actually reflecting what he's actually doing. And that there's no shame if he only wants one night during the week because of all that's involved. This is just let's see how this works. Let's make sure dad has enough time. Let's get them talking about what really is in their boy's best interest long term. I assume the 6-year-old will be starting kindergarten or first grade. Which one?
First grade.
First grade, Your Honor.
Okay, good. So it's not a first year. And he's probably pre-enrolled. But that's going to kick in here before long. In the next 3 or 4 weeks, right? School starts.
Yeah, 3 weeks, Your Honor.
So that changes things too. So again, attorneys are always able to massage these things as needed and as agreed to by the parties. And if there needs to be some modifications that are agreed to when things settle down and you really look at things objectively, I'm happy to sign off on agreed orders. And Mr. Potter, clearly, as you've asserted under the law, if 2 parents agree to something, it's presumptively in the kid's best interest because it's presumed the parents know better what's best for their kids than judges or attorneys. Okay. So, this is what I'm going to set up, but don't be ashamed or be shy if, as logistically this is being worked out, if it's not working, there can be even temporary adjustments made before the divorce itself is actually finalized. Okay?
Understood, Your Honor.
All right. Anything further today?
No, Your Honor.
No, Your Honor.
We are adjourned. Thank you.
Thank you.